Good morning, everyone. Good morning and good afternoon, everyone. Welcome to today's webinar. My name is Ilaria Bottigliero. I am the Director of Policy, Research and Learning at IDLO. A very warm welcome to all participants to today's webinar, where we will be launching our new IDLO report on women and customary and informal justice systems. Before we proceed with the panel, we have a distinguished panel today, and we are also very privileged to have the IDLO Director General with us today. I would like to share with you a few housekeeping rules. You are probably familiar with the use of Zoom, so it won't be long. I'll keep it quite short. You see on your right-hand side the Zoom webinar chat. Feel free to use it, of course, to interact with each other and to comment or to express your views and opinions through the chat. And we also have a Q&A session. Actually, we have two Q&A sessions dedicated to your questions, the questions that you would like to ask our panelists. And you can ask your questions by using the Q&A window to ask questions. The Q&A chat will be moderated, and we have my colleagues Rea and Raluca who will be moderating the Q&A chat. So feel free to pose your questions for the panel, the Q&A chat box. We will have two dedicated moments for Q&As after each panel. Kindly reminding you also that the session will be recorded and that we are live also on Facebook. So having said that, again, a warm welcome to all of you. Thank you again for joining the panel. And at this stage, it is my very distinct pleasure and honor to introduce the Director General of IDLO, Ms. Jan Beagle, who comes to IDLO with a very long career at the UN, including as a special advisor to the United Nations Secretary General on system-wide implementation of the Chief Executive Board decisions, and as the United Nations Undersecretary General for Management Strategy, Policy and Compliance. She also served as the Deputy Executive Director of the Joint United Nations Program on HIV/AIDS, UNAIDS, among many other positions. But today, I really would like to introduce Jan as a very committed advocate for gender equality and a very active member of the International Gender Champions, which is a leadership network that brings together senior female and male decision makers to break down gender barriers. So she has been really instrumental in spearheading the development and implementation of programs and approaches throughout the UN to improve and accelerate diversity and inclusion, women's empowerment, and rights-based approaches. So it's my pleasure to hand the floor and introduce Jan Beagle, the Director General of IDLO, for the launch of our report and some introductory remarks. Jan, the floor is yours. Thank you very much.
Thank you very much, Ilaria, and good morning, good afternoon, good evening. It's a great pleasure to welcome all of you joining from around the world, and we are very pleased to see a truly global audience coming together from locations in Asia, the Pacific, Africa, Europe, North, Central, and South America. This is really a great pleasure. And I have to say that for me, it's a particular pleasure to be with you today, as when I was a young diplomat, I was part of the negotiating group that produced the Convention on the Elimination of All Forms of Discrimination Against Women, and have followed the work of CEDAW very, very closely over the years. So it's a distinct honor for us to have with us today the chairperson of the CEDAW committee. I'm very pleased to welcome her. I think that most of you know that the International Development Law Organization is dedicated to promoting the rule of law and access to justice in every region of the world, we work to advance the 2030 Agenda on Sustainable Development with a special emphasis on SDG 16, on the rule of law and access to justice for all, and Goal 5, on gender equality and empowerment of women. And we see customary and informal justice as a key area of engagement for achieving both of these goals. And that is why I am delighted today to launch our new report, Women and Customary and Informal Justice Systems, which you can now all access on our website. I invite you all to consult it, to share it, and to use it. It's a groundbreaking report that culminates more than a decade of research and programming experience at IDLO. The publication is the third in a series, Navigating Complex Pathways to Justice, that was launched in 2019 to advance policy dialogue, distill lessons, and offer concrete tools, recommendations, and good practices in support of engagement with customary and informal justice systems. The series launch was accompanied by global consultations and dialogue, bringing together members of the judiciary, customary justice leaders, government officials, academia, civil society, and development practitioners. And this work is also informed by IDLO's work in many countries, together with civil society and communities, to promote customary and informal justice systems that are gender responsive and aligned with international human rights standards. As we know, the importance and value of customary and informal systems have often been left out of discussions on justice, law, and development, especially at the international levels. But the reality is that globally, the majority of disputes are resolved outside of formal structures. And the vast majority of justice seekers in informal systems are women, as well as the poor, minorities, and other vulnerable groups. And we know that many customary and informal justice systems reflect male-dominated societies, perpetuate patriarchal values, and produce discriminatory and harmful outcomes for women and girls. Years ago, I remember when I was representing my country, New Zealand, in the third committee of the General Assembly, it was very difficult to discuss these sensitive issues. But today, it is recognized that we need to place women's issues and concerns at the center of discussions on policy directions and entry points for engagement. And the Committee on the Elimination of Discrimination Against Women is central in this. In its General Recommendation 33 on women's access to justice, the committee has observed a range of models through which practices embedded in plural justice systems could be harmonized with the Convention in order to minimize conflict of laws and guarantee that women have access to justice. So I'm very pleased that the chairperson of the committee, Ms. Hilary Bedemar, is joining us today, and she will provide us with key insights from the perspective of her committee. In summary, the report that I have just launched brings together current research, expert perspectives, and programmatic experience addressing the evolution of legal and policy debates on women and customary and informal justice, challenges women encounter in accessing justice through these systems, gender-focused engagement entry points, modalities, and good practices, and policy recommendations to improve women's rights and access to justice. Ilaria will introduce the report to you in detail, and I invite you all to explore ways in which the recommendations can be turned into action in your respective organizations, projects, interventions, or research. And we welcome continued engagement with you on this very important issue. I would like to take this opportunity to extend IDLO's thanks to all the experts and partners who participated in our global consultation and online survey. Many of you are also here today as panelists or audience. This is a complex and sensitive subject, but one which needs to be discussed openly and frankly to ensure that customary and informal justice systems benefit women and protects their rights. We need to build and strengthen partnerships that support women's human rights and their access to justice, and especially to ensure that women's voices are heard at local, national, and international levels. We look forward very much to hearing from you all today. Thank you.
Thank you very much. Thank you, Director General, for this very nice introduction. And let me take a few moments to go a little bit more in depth into the substance of the report, which you now see live on our website. It's available at the address that you see on the screen. As the Director General mentioned, Women in Customary and Informal Justice Systems, our report brings together current research, expert perspectives, and programmatic experience on the topic. This topic has been often controversial and remains a sticky point in justice and development conversations. The IDLO reports, however, starts from a very basic assumption: the recognition that globally, disputes are largely resolved outside the formal courts through customary and informal justice systems. This is especially valid for women. Issues of great significance to women, such as inheritance, family formation, divorce, property rights, control and governance over land and natural resources, and even violence against women and girls, are mostly resolved or adjudicated through informal mechanisms. If we are serious about justice for women and justice for all, the realization of SDG 16, people-centered justice, justice accelerators, and even justice innovations, we simply cannot ignore the reality of customary and informal justice and its millions of users. The IDLO report does not turn a blind eye to the challenges women face when using customary and informal justice systems. These are enormous and shouldn't be underestimated. For example, women can face significant social pressure not to speak out or to maintain peace in front of a dispute, including disputes of serious nature, such as those involving gender-based violence. Also, it is well known that most customary and informal justice systems feature few or no women in decision-making panels, with men mostly presiding over these systems. Women are often not being invited or allowed even to speak, and women's testimony often does not hold the same weight as that of men. Our report stresses that women who are poor, migrants with limited education, living in rural or remote locations, women from minority groups, or those living with HIV/AIDS, face distinct and additional challenges, making intersectionality an important consideration that should inform all of our thinking about engagement with customary and informal justice systems. The IDLO report also looks at the interaction between formal and informal laws and systems of justice. It is clear that the gaps and discriminatory content in formal laws greatly contribute to women's inability to access their rights and to their turning to local and informal justice solutions. In other words, formal systems are not perfect either. When formal laws and courts are inaccessible, remote, difficult to understand, expensive to navigate, and in addition, when formal laws and implementation structures in many parts of the world do not offer adequate protection for women, such as, for example, in cases of violence against women, discrimination in marriage and family, or unequal land rights, women are compelled to turn to customary justice, whether they like it or not. Many times, in fact, it is not a preference. While recognizing the challenges and complexity of engagement with customary and informal justice systems, there are models, lessons, and approaches that can be shared to expand women's access to justice, women's empowerment, and gender equality when engaging with such systems. The strongest contribution of our report to current and programmatic debates is precisely the identification of entry points and modalities for a gender-focused engagement with customary and informal justice systems and concrete policy recommendations. Now, during the panel discussion, we will review and discuss these entry points and engagement modalities. And we hope to continue engaging with you and all the wider justice and development community to identify ways in which we can pursue better access to justice for women, both at the formal and informal levels. Now, when you get a chance to go through the report, you will see that the report provides 7 recommendations for engaging with customary informal justice systems to facilitate and improve justice for women. These recommendations stem out of a wide set of consultations with women's groups and the broader international development community. But especially, and first and foremost, they benefit from IDLO's practical experience in the field, working to enhance women's access to justice and advance women's rights worldwide, including in some of the most difficult and challenging environments. Our programmatic portfolio on engaging with customary and informal justice ranges from delivering justice through alternative dispute resolution in Somalia, supporting the work of the Alternative Justice System Task Force in Kenya, supporting a program on community justice in Uganda, strengthening the capacity of traditional elder courts in Kyrgyzstan, and involving traditional actors in criminal justice sector reforms in Mali, just to mention a few. Our regional manager for Africa, Romualdo, my colleague, will be presenting on these programs later on throughout the panel. At IDLO, we aim to strengthen and expand this portfolio to put into action the recommendations of our report. But let's take a couple of minutes to look at those recommendations and see what did we learn throughout our experience engaging with such systems. Well, first of all, we learned that we need to ensure that women's human rights are recognized as central and indispensable for engagement in any conversations with customary and informal justice systems. It is critical to place women's issues and concerns at the center of any discussions. This also means thinking about the diverse group of women and the range of contexts they are situated in, so that we also stay true to the principle of leaving no one behind. Second, we need to support the empowerment of women to make informed decisions when seeking justice and participating and benefiting from customary and informal justice decision-making processes. We also have to deepen efforts to support such systems if they are committed to improving women's rights and their access to justice. It is then very critical to facilitate safe environments for women to enjoy their rights and pursue justice. Something else that we have learned through our experience is the importance of ensuring that women's voices at local, national, regional, and international levels are heard, amplified, and constitute a critical part of the reform strategies. We then learned that strengthened investment in participatory and collaborative research that informs policy and programming is essential. So we need evidence-based decision-making processes to engage with such systems. And finally, partnerships and alliances are fundamental. Of course, working at the local level is indispensable. So we can't approach such systems with top-down solutions. We really need to take it bottom-up in partnership with local communities, the people, women's groups, and local institutions. Now, today, our panel will focus on three key issues that are before us, having to do with what can be done to improve strategic engagement with customer and informal justice systems for the promotion and protection of women's rights. What are the practical entry points and good practices that offer concrete pathways for engagement? And finally, what are the challenges presented by COVID-19 for strategic engagement with customer and informal justice systems for the enhancement of women's human rights? How can we address these challenges? These are very complex questions, but on the other hand, we have a brilliant panel and we have a lot of expertise on our panel, and I'm really, really pleased to introduce and to welcome our speakers today. We will have a set of two panels whereby three speakers at a time will contribute to the discussion. We will start with the first panel of speakers composed of the chairperson of the CEDAW committee, Hilary Bedema, Emily Gill, the Senior International Legal Advisor at the Commission of Jurists, and Beth Roberts, who is a Program Manager at the Center for Women's Land Rights in Landesa. We have shared with you their bios and their long experience. They all bring to the panel a wealth of experience, and I'm extremely happy and privileged to have you all today responding to some very, very difficult questions. So we are looking forward to hearing your views and your perspectives from your different work experience and life experience to the issue of women's engagement with customer and informal justice. After the first panel of speakers, we will open the floor to a short session on Q&A. So I invite you already to think about some questions that you may want to pose to our panelists or in general to those involved in the discussion. My colleagues, Rea and Luca, are there to take up your questions, and I will be then sharing them with the panel itself. So without further ado, it is my very distinct pleasure to give the floor to Ms. Hilary Bedema, who is the chairperson of the CEDAW committee, a very good friend of IDLO. Thank you so much, Hilary, for being here today. It's a real privilege. We are extremely honored to have you here. And I leave the floor to you to address some of these issues that are challenges, and yet they present so many opportunities. Thank you very much, Hilary, and the floor is yours. And if you could unmute your microphone, thank you.
Thank you very much. Thank you. And I want to thank the Director General also, Jan Beagle, for the introductory remarks. I will begin by thanking both of you for setting the tone for this webinar on expanding women's access to justice and gender equality. You've asked me to begin with the challenges, if I'm correct. I believe that is so. Very well, then I will proceed. Now, the first challenge is the paradox that we face in customary law and the customary justice systems. First of all, we know that customary law is a set of established norms and usages derived from the lives of people, and they are embedded in and inseparable from the ethos of the society and the beliefs. So the first paradox is that we are asking people to take a critical look of what they've lived and know throughout their lives. It is such that even those who are subject to discrimination under this system have it so embedded in them that to distinguish the two and to take action against the two is sometimes a problem. This is because of the areas in which customary law impacts our lives, women's lives, and the lives of the society. So the first challenge is precisely because of the belief in the system, even though parts of it may be inimical. There's also the issue of the internal conflict of laws, internal inheritance systems within one country, the dual and plural nature of customary law. So this is the second level of complexity. The third level is what has already been mentioned, that is the area of patriarchy and the fact that it seeps into the society deeply, and that customary law is recognized for the maintenance of societal order, for day-to-day life, rites of passage, and right from the public to the private. And that means the entire spectrum of one's being. So these are the three complex issues with which we walk into this discussion on the customary judicial systems and women's access. Secondly, the situation is that it is such that issues of discrimination and inequality, and this is the perspective I come from as a member of the CEDAW committee. I'm first coming at this topic from the perspective of discrimination and non-equality. Now, for this reason, when we look at the areas that customary law regulates, as you have rightly said, there are areas that are germane to women's lives. The first I will mention is the family laws, marriage, divorce, polygamy, inheritance, and indeed death. In some countries, in the event of death, the funeral and even the ownership in the body, in the corpse of the deceased is within the family. So that already has an impact for widows being part of this ceremony and eventually claiming their rights under inheritance. We also come to the issue of land rights. And there's a saying in my country that all power resides in land. And especially in countries where land is a source of everything, food, income, employment, earnings, social value as a settlement, way to live, symbolic and ritual associations. This is very germane. Therefore, when you put this against the dynamics of gender and class, and the fact that women are not recognized in many societies as people who can own land, especially family land, precisely again because of patriarchal considerations, that when they get married, they will take family heirlooms, including the land, into the matrimonial homes to be handled by their husbands, also poses a question. And you rightly said that there are discrepancies or differences between women and between the groups of women. They are not homogeneous. So how this impacts the rural and urban poor is also another matter. There's also the issue of the area of torts, which is not very much alluded to. In customary law, especially the tort of defamation and seduction, again affects women more because of, when we look at seduction, it implies that men have rights in the bodies of women and in their ability to take decisions. In fact, women are still property of men. And the law of seduction, when you look at customary law, is slanted that way. There's the issue of leadership that you have alluded to. But one thing I would like to point to is the role of traditional women leaders. In my country, we call queen mothers, and the fact that they're excluded from leadership positions. Our general recommendation 23 on women in public life refers to this. And notes that states reports show that in certain cases, laws exclude women from exercising royal powers or serving as judges, religious tribunals, and so on. And that these provisions discriminate against women and deny the advantages of their involvement and skills in the area of the lives of their communities. And this is against, it flies against the provisions of Article 7. Customary practices that discriminate against women, like widowhood rights, customary servitude, witchcraft allegations, FGM, and food taboos are also another area. Then we look at the of mainstreamed gender into take this further when we have constitutional and legislative provisions that give that customary laws that are inimical to dignity and so on should not be upheld. We hardly ever find a referral to human rights or gender in these provisions. So the provisions which appear laudable on the face of it do not go far enough to address the position of women. So these are the main challenges that I can talk about immediately. And the challenges go to the pervasiveness of customary law in all aspects of life, the absence of leadership, the absence of robust constitutional and legal provisions, even though we can find some good practices there when we get there. Especially now with the advent of COVID-19, we are going to find that customary legal processes are going to loom even with greater importance because they are closer to the people, they resonate more with them, they address the barriers of the formal system, which are the psychological barriers of accessing formal legal systems, the financial barriers, the language barriers, and all. For all these disadvantages, the traditional systems provide a one-stop answer or a facial one-stop answer, which may not be the case in reality. And so these are the challenges that I wish to flag in my opening statement. The CEDAW committee has dealt with some of them, but we will deal with them when we come to best practices and the recommendations they make to address these challenges. Thank you very much.
Thank you so much. Thank you so much, Hilary. It's great to hear your perspectives, and thank you for stressing the level of complexity of these systems. These are not simple or one-size-fits-all systems. They are very different depending on the context, and of course, depending on the reality. And they need also ad hoc solutions and tailored solutions. And thank you also for reminding us of how COVID-19 has indeed affected access to justice in general for women and sort of shifted the balance towards an enhanced use of customary and informal justice systems, stressing even more the need for engagement. But I would like to turn to our second panelist, Emerlyn Gill, who is a senior international legal advisor at the International Commission of Jurists. Emerlyn, in your long experience at the Commission and beyond, what would be your take on engagement with customary and informal justice systems, and how do you see the main challenges unfolding and the role of women in making these systems more effective? Thank you. The floor is yours.
Thank you very much, Ilaria. Before I respond to your question, I would first like to thank colleagues at the IDLO for giving us this opportunity to speak today. And good afternoon, everyone. Also, I would like to congratulate IDLO on its new report on women and customary and informal justice systems. I see that indeed, as you mentioned earlier, the report has very well crafted policy recommendations, particularly on how to pursue gender-sensitive reforms of customary and informal justice systems. And I'd like to reflect on what you just asked, particularly on one of the entry points identified in the report as a concrete pathway for engagement with customary and informal justice systems. And that is on improving gender sensitivity and responsiveness of customary and informal justice actors. A gender-sensitive approach is one that attempts to redress gender inequalities by taking into account the specificities of women's and men's experiences and needs. It definitely requires paying attention to the different roles and responsibilities of women or girls and men or boys that are present in specific social, cultural, economic, and political contexts. This approach is indeed required if women are to be guaranteed universal human rights and to be free from discrimination. I also believe that engaging with CIJ actors or customary and indigenous justice actors in dialogues on identifying and eliminating gender stereotypes is key towards improving their gender sensitivity. It is important to emphasize that it is not really custom or religion that clashes with women's human rights. What are inconsistent with women's human rights, as Professor Naz Gania from the University of Oxford said, are those invocations of custom, culture, or religion as defense in order to oppose gender equality claims. And these invocations may come in the form of reliance on gender stereotypes that are harmful to women and discriminate against them. Gender stereotypes are social and cultural constructions of women and men due to their different physical, biological, sexual, and social functions. And more often than not, they are rooted in traditional notions about the roles and status of women and men in society. And in many instances, the invocation of these stereotypes, not only by CIJ actors, but also actors in the formal justice system, have hindered women from accessing justice. So I do believe that encouraging dialogue among CIJ actors on eliminating gender stereotypes would definitely help in strengthening their being gender sensitive. Thank you very much.
Thank you so much, Emerlyn, and thank you for pointing out the importance of tackling gender stereotypes and opening up a dialogue to really recognize the root causes that make such systems problematic for women. It's a point that it's very well worth thinking of and considering, especially in our practical interventions in the field. And that brings me to the next panelist, Beth Roberts, who is a program manager at the Center for Women's Land Rights in Landesa. Thank you very much, Beth, for being with us today. You have a lot of experience working at the grassroots level, assisting people living in poverty in rural areas to strengthen the rights, land, and productive assets. And of course, with the aim of furthering gender equality and social inclusion. So my question for you today would be, how do you see engagement with customary and informal justice systems, especially in rural context, and especially when decisions taken by such bodies affect so directly women's land rights and right to food and to other key natural resources. So Beth, the floor is yours. Thanks again for your contribution.
Wonderful. Thank you so much, Ilaria. And I'll echo Emerlene's thanks to IDLO and congrats on your report. Thank you very much for hosting this webinar. It's exciting to be here. And thank you to the previous speakers for your keen comments and to all of the participants. I'm looking forward to the question and answer period and hope that this that this time is fruitful for you, and that you're enjoying the rich comments that people have offered. So thanks for the question, Ilaria. For those of you who are not familiar with Landesa, we are a small organization that works directly on law and policy related to land rights. And our mission is to end poverty, and we apply a gender equality and social inclusion lens to our work. So as you've already heard mentioned, the chairperson from CEDA very clearly outlined the ways that land relate to customary and informal justice systems, and the fundamental way that land relates to justice, particularly for women, and particularly in rural areas. So just a couple of notes on the scope of the relationship between land and justice. So community-based property systems are estimated to be adhered to by approximately 2 billion people. And communities are estimated to hold as much as 65% of the world's land area through customary or community-based tenure systems. So that includes rural communities, indigenous peoples groups, those who are both most closely tied to land in terms of identity, spirituality, in terms of natural resource management, and also those who are most marginalized from formal legal settings. So Landesa seeks to connect the formal legal setting to rural land rights in practice. And this is especially keen for women because as the discrimination that women face in the context of accessing land, but also the context of accessing justice has already been outlined well. In terms of thinking through the felt needs of justice for women in rural areas, land is one of the most fundamental issues. So many conflicts within customary justice systems are centered around land, centered around questions of land allocation, which are more difficult for women. Women are often seen as secondary to men, to their husbands, to their fathers, to brothers. And also in the case of marriage and divorce. So women's social status, their familial status, their marital status really determines their access to land. And land is the basis for food security, is the basis for economic security, is the basis for social status and social security in rural areas. So our engagement with customary justice systems comes from that perspective of knowing that to create a sense of justice for women, the way in which land is managed at the community level must be fair. So we work in every country where we work locally. We work with customary justice systems. So I'll give a couple of examples. We're working on land reforms in both Liberia and Myanmar currently. So working on the implementation of the Land Rights Act in Liberia. And that act guarantees equal community membership for women and youth, which is a huge and progressive step forward. So working with customary authorities at the village level to sensitize them to the existence of the law and to see the advantages of supporting rights for women and youth is one of our key strategies in the context of those reforms. In Myanmar, likewise, there is a wide-scale land reform happening that is formalizing rights to land. And there's a mixture between the formal system and the customary system. At the village level, village administrators are both part of the formal system and part of the customary system. And so working as Everline mentioned, to shift the attitudes, to shift the way that power is invoked has been a key strategy in Myanmar. So working to help village administrators understand the benefits to communities of securing women's rights to land and making sure that women have a place within community structures for making decisions related to land. So so starting at the local level and then connecting up to even the global level is one of the key strategies that we use. So often introducing national level authorities to the realities on the ground is an important part of our work. It can be very difficult for officials to understand the realities for women in particular at the community level, and helping them understand how women's access to land relates to national level priorities, including climate action. I think relating community justice systems to climate justice is an important topic to raise in this context. So thinking through how do women manage natural resources? How do customary and informal justice systems relate to women's management of natural resources? And what impact does that have at the national and global level for the need for us to have community-based climate-smart agriculture interventions? And without climate justice, the economic justice and the human rights justice that we seek for women in rural areas will be impossible to achieve. And one further strategy that we employ is to answer the question contextually. So there will be multiple entry points to influencing and strengthening customary and informal justice systems to provide gender justice in any given context. So we focus on working with organizations, established civil society organizations that already have relationships with the communities. We work on connecting the impetus for gender justice at the local level to national level legal frameworks, and then to global level legal frameworks or regional legal frameworks. The African Commission on Human and People's Rights just recently approved a general comment on Article 7D of the Maputo Protocol, speaking to women's marital property, which is heavily related to land and will be adjudicated through customary and informal justice systems. The CEDAW Convention calls women's rights to land and natural resources fundamental human rights, and talks about securing women's equal legal personhood. And there's no more central place to secure women's equal legal personhood than through their rights to land in the context of their homes and their ability to engage with their communities and feed themselves and their families. So I hope that I've given a little bit of a picture of the centrality of land and natural resources to women's rights in the context of customary and informal justice systems. I'll wrap it up there and turn it back over. Thanks so much.
Thank you. No, thank you very much. And it's excellent to you were able to underline the relationship between customary and informal justice and women and natural resources. So I'm very much looking forward to continuing that conversation through the Q&A session, which we're going to start now. So thank you all participants for sending your questions. There are many questions that are coming in, and for all panelists, I would like to start with a question that is addressed to Hilary. We have a participant, Halima from Cameroon, asking whether it is really possible to protect customary law and women's rights at the same time, since with a focus on Africa, since in Africa, people and mostly women are tied to their customary law. So it's really a necessity to work on customary law and customary systems. Our friend is telling us that the need for engagement is there because people and women are actually tied to their customary law. So what would be your views on that, Hilary? Thank you. And yes.
Thank you very much. And I thank Halima for this question, because that is a conflict that we all endure, or we have to live with in Africa and as African women. I did mention that customary law is central to our lives. In my country, and as part the same as much of Africa, we cannot leave customary law aside when we name our children at birth. It is a strong spiritual connection that I would feel empty without. We cannot leave customary law when we marry, because marriage is a marriage between families, and to contract a marriage without going through the customary procedures would seem like an elopement and, you know, a smear on you, if I can put it that way. So I really understand strength. So what my perspective is, and the perspective of the committee is in large, is the harmful effects or the harmful aspects of customary law. How can we get around it? Let me give a couple of examples. In my country, for example, the National House of Chiefs is tasked with codifying customary law with the aim of deleting, abolishing those laws that are inimical to the inimical laws. Let me just put it that way. My issue there is that the aspect of human rights and gender is not robustly articulated. So this is a very good entry point, but we need to strengthen it. Secondly, we have a National Reform Commission, National Law Reform Commission, whose mandate is also the same or similar, to remove discriminatory laws. But again, here, we do not have, from my perspective, such a robust articulation of gender and human rights. Thirdly, the use of legislation, especially on the thorny issues and again, from my country, such as intestate succession, registration of marriages, especially customary marriages, the Land Act, are issues that we need legislation for. So the remit of this legislation will be to ensure that rights are protected, even within customary marriages, for example, even within land tenures, for example. Thirdly, the aspect I can see us going into, because Halima is talking about protecting customary law and protecting women, is to take preemptive measures. Some of these are, for example, will-making drives, proper education on proper titling of property. So these are some of the ways that we can segue between the two systems and ensure that we get the best from the two systems. Lastly, let me mention, if you don't mind, the importance of the international normative framework. These issues of customary law always come before the committee, and they are always the subject of concluding observations. Particularized ones are made for particular countries, custom-made conflict. And we've had them in relation to registration of marriages, to removing discriminatory customary laws, and to stereotypes that are custom impact. I would say that we should look at our concluding observations carefully, the ones that the committee issues. We should use them as an entry point or for advocacy. And we should watch the reporting cycle, the reporting procedure, to enable us glean, first of all, to feed into the procedure and to enable us glean what we can use to bridge this gap that Halima talks about. And just on a personal note to Halima, yes, I do feel this tension as an African woman myself. Thank you.
Thank you so much, Hilary. Thank you for your comprehensive answer. And thank you, Halima, of course, for raising this very important issue for us, for the panel. I have several questions, but let me move to a question having to do with the situation of COVID-19 and the changed nature of women's access to justice. We have a friend actually, Faustina Pereira from Bangladesh, who is a very prominent human rights defender, working with the poorest and a great champion of women's empowerment. So thank you so much, Faustina, for listening to this conversation today and for posing a question having to do with some emerging innovation in accessing formal justice systems or providing informal justice services in the COVID-19 scenario. So Faustina is saying that given that the usual channels of communication and services have been compromised or broken down, how are the grassroots justice services providers connecting to victims and target population at this time? So how can we ensure that the COVID-19 restrictions does not affect women and the grassroots sectors disproportionately, perhaps cutting even more their access to basic justice and services? And are there some digital innovations or some innovations in general that we can think of to enhance their access to justice or providing informal services through these difficult times? So that is a question for the whole panel. I'm looking at both all Emerlyn, Beth, and Hillary, whoever would like to take and try to answer Faustina's question.
Thank you. Did you give the floor to me?
I am asking actually all of you, and Hillary, very happy for you to answer, of course. Yes.
Very well. I'll just start and have my co-panelists. Yes, exactly. Thank you very much for this question. I will take it from three perspectives. First is that the CEDAW committee has issued guidelines in respect of women's rights under all the thematic areas and in the light of COVID. And we have asked in particular that women's access to justice not be compromised by the lockdowns, the restrictions on movements, the fact that there is likely to be more violence, especially when you have the victim and the perpetrator hooked up together without equal access of movement. So we have looked at the issue of access to justice. We've also looked at the role of women's human rights defenders and asked that their rights be not restricted. Attention should be paid to their rights because we recognize the increased and enhanced roles they will be playing under the issue, under the area in the era of the COVID-19. Thirdly, we have always recognized the role, and this one is, I'll give personal examples from my own country, of paralegals. Legal literacy volunteers, paralegals who work in the communities and therefore who can be reached easily and who can be a first responder to the issues of violence, and they are based at the community level. The issue of technology that is raised is really innovative and is commendable. We have asked for the use of technology to advance women's rights, but we have not particularized it in the context of the issue that is raised. So I take this as a very welcome recommendation that should be further advanced. I will just finally end with IEC materials distributed technologically, so that women know that even within the area of COVID, all the restrictions, their rights still remain untouched, and hotlines and areas, for example, that they can reach in the pandemic. Thank you very much.
Thank you very much. Thank you, Hillary. And we have a number of questions related to land rights. So Beth, I'm going to try to sort of summarize some of these questions. There are so many, but the question of women, the intersection between land rights, customary justice, and women has attracted a lot of attention. And for example, Esther is asking whether you would suggest, or is it something that we should think of, that unresolved land tenure systems in Africa could contribute to rural women lagging behind development. So do you see a link between the unresolved land tenure system in Africa and the underdevelopment of women, especially in rural areas? That's clearly for you.
Thank you, Ilaria, and thank you to Esther for the very good question. I think I'll start by saying that it's such a complicated topic, right? The land tenure system in Africa is not one thing. It's not one country. It's not formal or customary. It's both. They're intertwined. They interact, and neither one is the preferred system necessarily. Although in practice, the customary system is the preferred one. But what is unresolved is women's rights under those systems and women's ability to access justice under those systems. And so I would say that one of the key pieces of evidence we have around the benefits of women's land rights is that it changes the balance of power within the household. It allows women to make decisions alongside their husbands in ways that without land rights, they hold less power within the household. So at that very basic level, if women are to be equal economic actors, equal legal actors, to have equal decision-making power from household and village level all the way up to parliaments, women need to have equal power and control over resources. And so the fact that land tenure systems are complicated, are not clear, are unharmonized, and are deeply discriminatory against women hampers gender equality and hampers women's equal legal rights in every arena of their lives. So I would say a very clear yes to that, and also say it's a very clear challenge to us and to the development community as a whole, and to the world as a whole, to center women's rights to land and natural resources.
Thank you, Beth. And again, we have so many questions, and thanks to the audience for being so active and proactive. Emmerlyn, a question for you. We have a good friend of IDLO, Corday, Michael Warren, is asking whether the panelists in general, and I thought of directing this question to you, Emmerlyn, because it's about encountering specific examples of interface between customary and informal systems with formal justice systems that have been especially successful in promoting women's rights and access to justice. For example, delineation of jurisdictional boundaries between the systems, or perhaps formal judicial review of decisions in the customary system. So Michael would be interested, as many other participants, they would be interested in hearing also about some success stories in the interaction between formal and informal systems. Emmerlyn, the floor is yours.
Thank you for that, Ilaria, and thank you, Michael. But before I respond to Michael's question, I also want to add to what Hilary just mentioned earlier about the context of COVID and women's human rights. And we've been having discussions with judges, especially those who are dealing with cases related to women and the family, on the rise of domestic violence and intimate partner violence during lockdowns in a wide variety of countries. And what occurred to us there is that it's really important at this point, and I would have to go back to what I mentioned earlier about gender stereotypes and gender discriminatory practices, that it's really important that this pandemic has really highlighted how important it is to continue engaging in dialogue, justice actors, whether in the formal or informal justice systems, on eliminating gender stereotypes and gender discriminatory practices. this pandemic has only highlighted the inequalities in our society, especially how women are viewed as subordinate to men in many contexts. And the question also related to what are the ways by which to protect women, prevent domestic violence and intimate partner violence during this pandemic. And from our conversations with judges, and I believe this can also apply to a lot of other contexts, is that you have to consider what is the situation of women in that particular area or in that particular country. For instance, there was one way by which women can report, for instance, in France, which is the establishment of one-stop centers for women in grocery stores or pharmacies, for instance, which are mostly frequented by women, especially, during this pandemic, including during this pandemic. So one-stop centers were established there so that they can report violence or violence against them in these areas. However, for instance, this cannot be applied in certain countries. Think, for instance, in a country where, because of patriarchal notions, during the lockdown, only one person can leave the house. So in countries like Malaysia or in the Philippines, where only one person is given the pass to be able to leave the house in order to go to get groceries or medical supplies. And usually this pass is given to who they call as head of the family, which is the man. So in the past few months, in countries like Malaysia and in the Philippines, especially during the early days of the pandemic, those people who would go to groceries, who would go to pharmacies, are not the women. It's the men, because it's the men who are given the passes, because they are the heads of the families, because of the patriarchal notions of who is the head of the family in these countries. So again, it's worthwhile to consider the context before considering adopting certain practices in other countries that may have worked for women to protect them from intimate partner violence or domestic violence. To respond to Michael's question, yes, there have been quite successful interactions where discriminatory decisions or discriminatory practices from based on custom or religion have been overturned by the formal justice system. So one example would be a decision in Indonesia with respect to the inheritance of land, where the court said that the custom of giving the land to the male line, even though there are daughters in the family, that is against CIDO. So that is actually for us an emblematic case where the synergy between you have the synergy between the formal justice system and customary law, where the formal justice system prompted customary law actors to actually consider having decisions that are in line with CIDO and upholding and promoting women's human rights. Ilaria, can I just also respond very quickly to one other question that was raised by one of the audience, somebody from the audience, and I think it's very important, and this relates also to Michael's question with respect to how women operate to protect or promote their rights within the context of religious law, or where there are religious law adjudicators. In some countries, women have been fairly successful in doing that they have actually been successful in reinterpreting religious law so that it promotes gender equality. But in some countries, for instance, in Malaysia, there are still groups of women that are facing very serious challenges while undertaking this. And this is something that we are still working on in these countries. And this reinterpretation of religious laws or customary norms, especially on religious laws, is based on the premise that all rights are universal, indivisible, interdependent, and interrelated. And so if you look into this, then women are human beings, of course, and they should also still be able to enjoy their freedom of religion or belief. And what are the vital factors for women to realize their religious freedom? First, women should have the ability to belong to a faith of their choice or the faith into which they are born. And second, women should be able to continue to belong without being discriminated against within their culture or within their religion. So this is the premise that many women's groups have been trying to forward within their own religions, within their own cultures. Some have been very successful, but some are still facing serious challenges. Thank you.
Thank you, Emerlyn, and thank you also for the question on freedom of religion or belief, which is essential and integral to the discussion on customary and informal justice. So thank you also for addressing that. We have so many questions, but I'm afraid we have to now move on and move to the second set of panelists. So I would like really to thank you, Beth, Hilary, and Emerlyn, for your excellent presentations and contributions, and for the questions that you were able to address for us. And I would like to move to the second part of our discussion with the second panel of speakers. Our colleague, IDLO colleague, Romualdo Mabezenge, who is the regional manager for Africa of IDLO. Welcome, Romualdo. We have also with us Dr. Fiona Hukula, who is the Senior Research Fellow at the Papua New Guinea National Research Institute. Really nice to have you on the panel, Fiona. And we have Rita Asirolakor, who is the Chief Executive Officer at the Uganda Women's Network. So thanks again, Rita, for joining this panel today. Same set of questions, same set of challenges, and but also, again, same set of opportunities. So it would be great to hear from you, starting from Romualdo. What would be your views from the field perspective? IDLO has implemented many programs on customary and informal justice, but in your own background, you also have a long experience in working with democracy, governance, with a focus on rule of law, development justice, justice sector support, of course. So from your practical experience, what would be the value and also the challenges of engaging with such systems, especially when we're talking about women? Thank you, Romualdo, and the floor is yours.
Thank you very much, Ilaria, and allow me to also extend my welcome to colleagues who are on this panel and also on the previous panel, and to echo the, if I can call them, the felicitations that extended to IDLO. We are very much appreciative of them. And I think the brief that is being launched today, in a lot of ways, speak to what we have experienced as we engage with customary and informal justice systems on the continent. I think what is emerging, and this has been a running, at least in the presentations that have been made earlier, is that it's very complex to deal with customary and informal justice systems. They are not homogeneous. They vary from country to country. The contexts differ. And I think one other issue that we tend to forget is that they are not static. customary law itself is continuously evolving as the people and communities develop. The customs do change, and in some instances they improve, in some instances they regress as people define them for purposes of maintaining hegemony over resources. So we are not speaking of, if I can call it, almost a monolith system of law that has not evolved over time. As IDLO, we have, and I want to focus a little bit more, Ilaria, on the strategic engagement and our experience from a practical perspective in terms of the good practices. And in a lot of ways, the brief that we are launching today does speak to some of the, or most of the entry points. But I do want to just reflect on them, giving practical examples. I will not repeat the challenges. As I said, those have been articulated quite extensively by the other colleagues. As part of entry points, and this is, as I said, also acted in the brief that is being launched, one of the key areas has been the need to adopt and implement normative frameworks that benefit women and promote their rights. And certainly my experience has been that this is particularly important. We've done this, and I'll refer specifically to our work in Kenya. Kenya is very interesting because in Kenya, the government of Kenya, or the constitution rather of Kenya, does recognize the prominence and puts a place of prominence for customary and informal justice systems. Through Article 1592 of the Constitution, they clearly indicate that the mandate is provided to customary justice systems also be able to decide cases, and the judiciary does respect that. So this is quite positive in that the Constitution itself recognizes the centrality of customary and informal justice system lives of the people. Kenya has gone forward beyond the provision that recognizes customary and informal justice systems. Kenya has gone forward to, through their judiciary, to basically establish what they call their task force on traditional, informal, and other mechanisms for dispute resolution. This is commonly referred to as the Alternative Justice System Task Force in Kenya. The purpose of this task force is to actively engage with the citizenry and ensure that AJS, or customary and informal justice systems, are actually promoted. Now, this is positive, and as I said, this is good in the sense that there is a coming together or a bridging of the formal and the informal, where there is actual recognition both in the Constitution and also by formal justice actors of the centrality of customary and informal justice mechanisms in dispute resolution. The one thing I will say is that in terms of our experience, the CIJs and formal should really not be viewed as absolute separate. The reality is that most people at the community level, because they not access or start at the end of the formal system, they start at the CIJs, and in some instances there are federal pathways that then allow them to eventually end up in the formal system. So instead of looking at these as absolute separates, the idea should be looking at how you look at them in a way that allows for development of referral pathways that allow people to then also begin to interact more where issues that could potentially harm women might arise. So that's one that I wanted to reference in terms of adopting and implementing normative frameworks. As part of that, in Kenya as well, and also in Sierra Leone, IDLO is working, obviously, this was also spoken to by some of the earlier speakers, around the elimination of discriminatory laws, identifying these and ensuring that we are able to address the justice gaps or the legal gaps that that offer protection, or the legal gaps that offer a lack of protection rather for women, women's rights, and ensure that those laws that are inimical to women's rights and the rights of vulnerable groups are actually repealed, and in some instances also ensure that those customary practices that are also inimical are codified and then removed from practice, so that people are essentially using the formal legal instruments to ensure that some of these practices do not persist. Beyond the adoption, I want to very quickly speak to maybe two other entry points. And one is pursuing gender-sensitive reforms of CIJ systems. And some of this we have seen, particularly, again, I'd like to speak to our work in Kenya, where we have worked with the Qadi courts. These are non-formal courts that apply Muslim Sharia laws, and what we have realized is working with Qadi courts and sensitizing them, particularly around the international best practice, human rights norms. There is room to essentially ensure that at the end of the day, CIJs improve in terms of their gender sensitivity, and that actors within the CIJ space also begin to take on board some of the international best practice in terms of how they adjudicate on matters. In Somalia, again, to give practical examples, I know we've got some research work is going to come out in terms of our work with alternative dispute resolution centers in Somalia. We've done quite a bit of research to strengthen and bring out clearly how these ADR centers have operated, and the specific role that are occupied by some of the women adjudicators in these centers, and how through developing protocols, through developing clear standard operating procedures, we have been able to ensure that the CIJs in a very difficult and complex environment such as Somalia actually taking on board constitutional and as well as human rights principles in the manner in which they actually deliver justice. And this is particularly important. I think it is accepted by, generally accepted, that the majority of people tend to access the CIJs before or they access the formal justice system. I also want to speak to a point which I think is absolutely critical, which is around building and expanding alliances. We are working on this in Uganda, where we are working with women's groups and our community justice program there, to see that how we improve access to justice for women. And also at a regional level, there was a contribution earlier about the role of paralegals. As IDLO, we have worked to develop a paralegal network for East Africa. And part of the remit of this paralegal network is obviously strengthening at the community level both knowledge and capacity of people within the various communities to be able to access and also provide some advocacy and education with respect to the extent to which CIJs can be able to do some of the matters that occur at the community level, and what really should be moved on to more of the formal justice system. So working very strongly with paralegals has proved to be a key aspect of giving access to justice through CIJs. As I said, looking at building collaboration that exists between the CIJs and the formal justice system. To this end, IDLO has been supporting the convening since 2018 of the East Africa Chief Justices Conference. This is a gathering that brings together all the chief justices or heads of judiciaries in East Africa, and essentially what we have done is we've also sought to bring them at the same table with CIJ actors, so that there is that sharing discourse, building understanding, and then ensuring that at the end of the day, the two do not look at each other as opposing, but that the former begins to look at CIJs as complementary to their work. And interestingly, in Kenya, we have seen a huge shift where to decongest the courts, the most matters are now being referred, particularly matters around family law issues, are initially referred to court annexed mediation. And the mediators are community leaders, people who at least basically looking to try and see that before a matter actually makes it into the formal realm, is there an opportunity to dispense with it at the community level, and if possible, ensure that the dispensation of that matter is done within the context of the Constitution, within the context of international human rights, and protection of all the rights that are necessary, particularly for women and marginalized groups. So
yes. I'm sorry to interrupt. If you could please conclude, because we have so many questions, and I would like to give time to the two speakers, Fiona and Rita, and take a lot of questions. So please, if you could.
Okay. Yeah, I was. Thank you, Ilaria, and I was literally almost finishing up. So the last point that I wanted to make relates to maybe very briefly touch on the impact of COVID-19. What we have realized, and some of the speakers spoke to this, is COVID-19 came with a lot of restrictions. Governments imposed restrictions, and obviously the formal courts were closed. And that also meant that movements were restricted. So to the extent that even accessing the informal justice mechanism has become a challenge. So it's not really only a challenge for formal, it's also a challenge for the informal justice mechanisms. And what we have begun to see is a lot more of disputes being handled within families. And certainly the work again of community paralegals again comes to the fore in respect of dealing with some of these, and the networks that we've been working with to focus more on the human rights side is certainly going to be a key enabler in terms of accessing and improving the rights of women and marginalized groups. So I'll stop there, and thank you very much.
Thank you. Thank you very much, Romualdo, and thanks. Thanks also for pointing out that customs do change, so systems are not static, and there is a lot of course, potential and opportunity in change. And with that, I would really like to hear the perspective of a completely different region. So Fiona, you are the Senior Research Fellow in the Papua New Guinea National Research Institute. How do you see the issue from your own regional perspective, where so many challenges also have been noted, but also avenues for improvement and good practices come from there? Thanks, Fiona. The floor is yours.
Thank you, Ilaria, and congratulations to IDLO on the launch of the report. So I Good night from Papua New Guinea. It's 11:30 on Thursday night. I'd like to speak a bit. I'll start probably where Romaldo left off on COVID and some of the challenges that I know we've faced here in Papua New Guinea and also in the region, especially relating to access to justice for women during lockdowns. We know that that has been a real issue in accessing not just formal justice, but really informal justice as well, with transport in the lockdown where there was no transport, no access to money, things like that. I can speak to the issues for Papua New Guinea. We're not in a lockdown now, but there are still significant challenges, I would say, because of COVID and social distancing requirements, and also for travel for people accessing any form of justice, but particularly informal and customary justice, because for those who may not be familiar, I'm speaking about my country. So Papua New Guinea is in the Pacific. It's the largest country in the Pacific. There's 8 million people, over 800 different languages, very diverse cultures. And so customary and informal justice is an extremely important part of our justice system in here in Papua New Guinea, but also across the Pacific. And I think in terms of looking at the report and speaking today, I'd like to speak to the practical entry points for supporting women to navigate the justice system. And this is in the report, especially looking at supporting the existing services. So, for example, here in Papua New Guinea, where we have most of our population is remote and rural, about 80% of our 8 million people are in remote and rural areas. There's geographical challenges, there's challenges around literacy. And so access to justice is mainly through the village courts and through informal customary justice. So with the village courts, there's around over 14,000 village courts and over 15,000 village court officials, of which about 900 are women. And the Village Courts Act specifically speaks to enabling women to access justice. And so as a practical entry point, this is the kind of entry point that I would suggest is useful for countries like mine, where there's village courts, entry points around local and traditional leaders or church leaders. And this, I can speak to that for the whole of the Pacific, where Christianity is a very large part of many people's lives. And supporting local women's organizations. So we have good examples across the Pacific, specifically here in PNG. I can give examples of where women's organizations have worked to help women access justice. So how, as an entry point, working with human rights defenders and women's organizations in collaboration with government, mainstream, so formal justice systems, NGOs, but making sure that we have that local buy-in from the leaders. I think also helping to develop referral pathways. So, whether it's that traditional kind of referral pathway that we all understand, whether it's through the government health system or through the police or the formal justice system, or it's through other kinds of referral pathways that are identified by the communities themselves. So for example, if you go into a community and people mention that the local level government or the church pastor is someone that they can go to. And this is where I agree with Romaldo's comment earlier about this sort of separation of these two systems, which really aren't, because eventually in some ways they come if most people engage with the informal justice, most women, they will eventually somehow find themselves in the formal system, whether it's through the justice system, through the police, or through the courts, or having to access the health system because of a needing to get medical attention, for example, for a domestic violence case. So I think in terms of enabling women to navigate the system, it's also important to recognize that the system is other parts of the system, not just the justice system, so the health system, or if they are working at accessing safe houses, for example. And this is, I think, important for places like Papua New Guinea, where the kinds of justice that women seek are not only domestic violence and issues relating to violence, but more difficult kinds of challenges like sorcery accusation related violence. So while this affects both men and women and different families or whole communities and tribes, in some places the gendered nature of this kind of violence against women is really quite alarming. And the importance, the research that I've been involved with shows the importance of informal systems, customary justice, informal justice, in trying to make sure that accusations don't turn into violence, or where there is violence, there is ways to deal with these issues. Because as I've mentioned earlier, the reach of the formal justice system is quite difficult because of access to resources, but also because of the very remote places in some parts of the country. I think really that's what I wanted to speak to today, and really emphasize, and I've seen this in the report, on building those relations with what's already there on the ground, and the importance of community buy-in. So that's not only the customary and customary leaders, as in the men, but it's also getting the buy-in of women and women leaders, whether they're clan leaders, or whether they are leaders through the church, or whether they're local level government leaders. So we have everybody all on the same page, talking about issues that affect women, but also in the context of how it affects community. So because very much in the Pacific, we are about not just the individual, but about our communities and our families. So once again, thank you, Hilaria.
Thank you, Fiona, and absolutely, local buy-in, local ownership, community engagement, these are essential elements that we need to keep on working on. And that actually brings me very nicely to our next panelist, because our distinguished friend Rita Hope Asiro Lakor is in fact the Chief Executive Officer of the Uganda Women's Network. So she is really, she has direct experience on the importance of engagement of local and grassroots networks in terms of facilitating the realization of women's rights to customary and informal justice. So Rita, let me turn to you, and we would like to hear your points of view and your perspectives on how the grassroots communities, local communities, women's movements can indeed give a push to the traditional approaches that many times provide challenges for women's access to justice in terms of customary and informal systems. So Rita, the floor is yours. We look forward to hearing from you. Let's see if Rita can hear us. Yes, Rita, there you are.
Thank you. Yes.
Good evening from Uganda, Kampala. It's coming to 5 p.m. First of all, I would like to thank IDLO for the opportunity to participate in the development of the brief and also to be on the panel today. I'm happy to be here. Just a little bit of a background. First of all, the customary and traditional justice systems or informal justice systems in Uganda is considered to be dependable by majority of the population. It is also considered to be quick and relatively inexpensive. Justice in Uganda is quite expensive, but it's also dictated by the culture and religion and mainly by popular public opinion. But I also want to bring to your attention that we have a dual legal system or regime where you have the formal justice system, but also the informal justice system is recognized. So we have an overlapping legal regime, and at times there's confusion. There is also a perception that the informal or customary justice system is more conciliatory than punitive, and therefore people tend to go more to that. However, despite the fact of the accessibility of the customary and informal justice system, women and girls still have a lot of challenges, and this has been compounded with COVID-19, as earlier on mentioned by one of the presenters or the panelists. Physically, socially, economically, there are serious barriers for women and girls to access justice, and that has created a lot of constraints for women and girls in access to justice. So going back to the question on what can be done, I can share with you some of the practical things we are doing to try and penetrate the customary and informal justice systems to improve access to justice for women and girls. One of the things that we have done is to document. We wanted to understand the positives of the customary and informal justice systems. In the past, how did they work? What are the negatives? What do we need to scale up? What do we need to probably do away with? And by understanding the traditional customary and informal justice systems, we are able to dig deeper and engage with the stakeholders, particularly those who hold power in those institutions. And we have documented that together with the institutions, we are now coming to see there are certain aspects of the system that can be done away with, and there are those we can still uphold. So documentation is very crucial, but more so popularizing the positive aspects. For example, on the issue of land, in some customs, actually widows were never chased. It is now individuals who are abusing the customs. So once we document that, then we use that to educate people and say your great-grandparents never did this. It is a few people who are now taking advantage of widows and orphans. The other is to demystify that women's rights erodes customary, traditional, and informal justice systems. There is a perception out there that women's rights erodes the culture, erodes tradition, and therefore there's resistance. So what we're trying to do is to counter that by providing relevant information and saying, actually, it does not erode. So information is very, very important. You'll all agree with me that the patriarchs have enjoyed power, privilege, and sense of entitlement due to these cultural beliefs and practices. And for us to give them a comfort zone is to assure them that women's rights does not take away your privileges, entitlements, and power. I've talked about appreciating the positive aspects of culture, and we need to talk more about one of the things we've also done is around women's rights organizations. Many times we go head on and say culture is bad, tradition is bad, everything is bad. But we want to listen more and say what are the good things about culture that even us as feminists, as women's rights activists, we start talking about those positive aspects of culture so that they do not see us as people fighting them. Then going to what can be, what are some of the practical entry good practices that can offer some pathway for engagement. We are working with the cultural institutions, and we are also building capacity of women to take up leadership in those institutions. For those of you who come from this part of the world in Africa, the traditional institutions are mainly occupied by men. However, we realize that there are few women, but also there is option for women. It's just that they never opened up. So now what we're doing is to train women to get into these institutions. So the culture and tradition work to discriminate against women so that they're able to work with the men in those spaces. The other is, of course, ensuring that these women are part of decision making. It was said earlier on that decision making does not belong to women, and we want to, they're also taking up the leadership. We have a system in Uganda where now traditional leaders are recognized and they're participating. Actually, this afternoon, one of the staff, they're working with one of the traditional leaders in Acholi, that is in northern Uganda. They are coming out to say that, you know, things can change, and the traditional leaders have become part of our, what you would call, mouthpiece to advocate for women's rights within their communities, because they have seen when women, for example, have land, there is food security in the home. And those are some of the examples we give them. And then going back to the last point, which is about the challenges of COVID, I want to agree with all my colleagues on the panel. I think in Uganda, we've had one of the, just a few days ago, we were told about 7,000 girls were defiled in this country during the period of the lockdown. We have so many teenage pregnancies. We have women who have been thrown off their homes because they were doing petty trade. So there's a lot of challenge that has happened. But given the fact that traditional or cultural institutions are the nearest and the first courts of instance where they can run, these women have been caught between the hard place and the rock. Now, that has affected a number of families, but the worst part of it is the men. Men have been rendered idle. Men who have been perceived or who have seen themselves as providers for the home can no longer provide for the home. So there's a sense of helplessness. Now, and then there's also the fact that there's a lot of unemployment that is happening and uncertainty. So what we are doing is to engage with the traditional leaders for people to start looking at alternative aspects of survival, which then can reduce domestic violence in the home. And of course, the other is to ensure that our women are participating in also providing for their homes to reduce the violence, because most of the women, as one of the colleagues said, close to 80% of our population live in the rural areas, and they're totally dependent on land. And now with the COVID-19, where people cannot even go out many times because of social distancing, they do not have the PPEs, even water in some of these places is a challenge. So our job is really to educate the population to ensure that we remain calm during these challenging times. I just want to conclude by saying issues of access to justice for women in Uganda, particularly using the customary informal justice system, continues to be one of the majorly used aspects because of the cost of access to justice in this country and the level of lack of awareness that exists due to lack of information that we have in the country. Thank you very much.
Thank you very much, Rita, for reminding us also of the importance of highlighting the positive aspects of culture, which I think is fundamental to engage in dialogue. So this is a very key point. And just by looking at the chat, the Q&A chat, the whole issue of capacity building and training of leaders, of community leaders, of women, is attracting a lot of attention. I have several comments and several questions on that. I wanted to acknowledge the comment from our friend Nursiabani from Indonesia, who was also part of the high-level group on justice for women. And she's agreeing with Romualdo on the importance of the paralegal's role, and mentioning that in her country, they're working on traditional and religious leaders who have been trained as paralegal to change the customary rules and religious interpretation that is discriminatory against women. Also, she mentions that the paralegals have established a citizens forum, and they're drafting a citizens charter on what they have agreed to be changed. So this can be taken also as an example of possibilities for changing the attitudes through training of those who are involved in decision-making in the customary and informal systems. But I wanted to pick up on a question from a friend from Ethiopia, Haben Sium, who is asking the panelists that in times of emergencies, people, for example, living in camps due to displacement, we find that informal justice in these situations is carried out by the community representatives, which are dominated by male part of the community. And so the question is, what could be done more to engage women to increase their participation in especially fragile and vulnerable situations? So when we're talking about refugee camps, or we're talking about conflict zones, or we're talking about women who found themselves really at the bottom of the fragility line, what could be the practices that are put in place to ensure that even in these situations, they are provided with a voice to engage in the customary resolution of disputes. So perhaps, I don't know if Fiona, you want to take a try at answering our friend Haben, or maybe Romualdo, Rita. It's open to the panel, whoever would like to take the question about a special situation of fragility for women.
Hi, Ilaria. I'll quickly try and respond
Thanks.
to it. We have had experience with it as IDLO, particularly in Somalia. As I said, this is a country that, as we all know, has experienced much and continues to experience fragility, and has similar settings to what the question is asking. What we have done is we have worked, as I said, with ADR centers. And within the context of those ADR centers, knowledge capacity building, trying to ensure that also women participate as adjudicators. These are instances where there is really no organized formal system. So the idea has been to build the capacity of those community leaders and begin to also ensure that women participate in these processes where possible, and have them equipped with the knowledge to be able to adjudicate on matters. So it is possible, and we, like I said, the research on the work in Somalia hopefully should be coming out soon.
Thank you. Thank you very much, Romualdo. And just by, again, scrolling at the picture, at the Q&A box, I see a question from Beatrice in Uganda. So maybe Rita, this is a question that you could help us address. Beatrice is mentioning that women in Uganda prefer the informal justice system because of the lack of technicalities, the use of local language, and the fact that they promote reconciliation. So is it something that you see as well, and how would you reply to Beatrice's comment?
I don't know whether that's a question. I think Beatrice was adding on to what I said. I actually mentioned that women prefer the customary informal justice system because it is more accessible, it is relatively cheaper, you use the local language, and I totally agree with her input So I don't think it's a question. That is the real, the true picture here.
Thank you. We are now again scrolling with through the questions. There is a person, a friend, Lydia, who is asking that given the varying context of customs across the globe, have we had successful stories that have gone beyond policy and legal reforms to create social change that have inadvertently prevented or reduced cases of sexual and gender-based violence? So there is a little bit of question about the relationship between, uneasy relationship between customary and informal justice and sexual and gender-based violence. And I wanted to hear, just broadening up the question a little bit, going from the specific details to the broader discussion about, Fiona, how do you see the relationship between customary and informal justice systems and situation of sexual and gender-based violence? There are several interpretations, and most tendency, the common tendency is not to engage with such systems when we are confronted with sexual and gender-based violence. So just in the last 3-4 minutes, tackling an extremely difficult issue, Fiona, I'll leave it to you to give us a few reflections on the interaction between the two. Thank you.
Thank you. And I think that's a very important question, and that's a challenge that we do face both here in Papua New Guinea and across the Pacific. And a lot of that comes back to also the ways in which we deal with these kinds of issues and the shame and things like that. And I think, and also because as I've mentioned before, there's people who are living in remote islands and remote communities. The only way to deal with these issues is through the customary and informal justice system. And so this is where the role of local leaders are important, and where the connection between that formal justice system. I certainly can speak to some of the things that are happening here in my own country, where communities now are taking ownership of these kinds of issues and coming up with community bylaws, things like that. And so I think it's also about how to monitor, if for want of a better word, of how to deal with these kinds of issues. So with the sexual violence, absolutely in the law here, they're not supposed to deal with it at that community level, but the reality is that they have to deal with it because there's no other, the formal system is not there. And so the challenge is now being able to make sure that those people who are dealing with these issues are also well versed with the law and are able to connect in some way with the formal justice system, or with human rights defenders or other people on the ground who can help them to provide that referral pathway, especially for those kinds of very serious cases. But thank you to the person who asked that question. I think that's a very important one, and always going to be a very big challenge for those of us who work in that space and who are interested in promoting customary and informal justice system, especially for our women and girls.
Thank you very much, Fiona. And I know that the conversation is just that we touched the tip of the iceberg, really. So it's a conversation that could continue for hours, and we would only be able to scratch the surface, really. So given that there are only 2 minutes to the end of this very, very exciting and an important panel, I would take those couple of minutes just first of all to thank the panelists. It has been really enriching hearing from you and listening to your perspectives and listening to your stories, to the challenges, but also to the opportunities. And what we take from this panel, I think that is a lesson for us to continue looking at the reality of women, and not ignoring situations that women face, whether it's because of COVID-19, whether because it's because of patriarchy, whether it's because of lack of access to natural resources or poor land tenure. We need to continue being attuned and look very carefully at the justice needs of women in order to responding to their needs. And if these needs are satisfied through justice that is held at the local level, at the customary level, then we need to engage with these systems and ensure that the justice outcomes are fair for women. And that's, I think, the path that we are taking as IDLO, but also broadly within the international development community, where more and more we listen to discussions around these areas, and we try to promote discussions around the justice needs of women, discussions that include alternatives and solutions going beyond the formal systems, because we know, as for experience and from what we have heard from our panelists, that formal solutions are simply not enough. So there are women who are left behind, there are women who are left with very, very limited access to formal justice. So for those women, we do need to make a special effort. We do need to engage, of course, keeping in mind that we cannot disconnect this discussion from the basic realization of women's rights. So keeping in mind that the women's rights should be put and kept at the center of the discussion while continuing our engagement. So I would like to thank the panelists for this extremely useful and insightful conversation. Thank you so much, and thanks to all the listeners, participants. We had so many answering and posing questions and interacting and exchanging on the chat. So it has been wonderful. Thank you so much, and see you next time with the next one. Warm goodbye to everyone from IDLO. Bye-bye. Thank you.